And are you Brittany Brown?
Yes, ma'am.
Are you the same Brittany Brown who was placed under deferred adjudication in 2023 CR 0042 for the offense of assault, bodily injury, marriage on February 6, 2023 for a period of 2 years? Is that you?
Yes, Your Honor.
And did you review that motion with your attorney?
Yes.
All right, state.
Your Honor, on or about the 6th day of May 2024 in Bear County, Texas, the defendant, Brittany Merrill Brown, did then and there fail to follow all TAP treatment recommendations as directed by the court and or Barrett County Community Supervision Department in violation of condition number 15.
How do you plead to that? True or not true?
True.
All right. Did you understand by pleading true to violation of condition number 15, the court could find it true, grant the motion, find you guilty, sentence you up to a $4,000 fine and up to 1 year in the Bear County Jail? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 15?
Yes, Your Honor.
Court will find violation of condition number 15 true. Is there a proposed agreement?
There is not, Your Honor.
All right. State, what are you requesting?
The state is requesting an extension of community supervision for 2 years and an amendment for DDRF as recommended by TAP.
All right. This is a misdemeanor case. So,
Your Honor, may I say something?
you want to raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. Yes. What would you like to say?
Well, I was gonna go to the SATA program, and they told me, they came and saw me, and they were like, get off their medication, and you can go to our program. So I got off the medication, and then they still denied me. And like, I've been here since January, away from my kids. Like, I was just hoping I could have another chance to do outpatient. I'm hoping for another chance, Your Honor. I'm begging for another chance.
Okay.
That's all I have to say.
All right. This is what we're going to do. We're going to come back at 2:30 and I'll give you my decision at that time. Okay.
Yes, ma'am.
All right. Thank you.
Thank you, Judge.
All right. We're going to go back on the record in 2023 CR 0042, Brittany Brown. And where we left off, Ms. Brown, you had told me some issues you were having. All right. I'm not a medical doctor, but before you go off of medication, it may be best for you to contact your doctor to see if that's something you should be doing. You understand?
Yes.
All right. So on this one, she was placed on probation in 2023. I'm not going to extend her. So probation, you all are recommending on Ms. Brown, you all are recommending SATF?
Judge, the recommendations for DDRF.
All right, DDRF. All right, and has she already been approved? There's no other.
Your Honor, I believe there was a similar issue with when she got off her medication to go to SATF, and then the SATF didn't accept her after that. And then I think, at least according to my client, there was an issue with DDRF not accepting her because she had gone off of her medication. So I think there was an issue on.
All right, so Ms. Brown, are you currently on your medications?
No, and I haven't been able to get back on them since SATA told me to get off of them so I can go to the program. And I got off of them and they just still denied me. And then I still haven't been able to get on meds. They haven't gave them back to me. And I've been off since April.
All right, so here's my question. The medication you've received, who was that through?
It was through here.
All right, so probation. Can we make sure that the jail knows that she's supposed to be on medication? So
it looks like the eval is for MIC supervision only,
okay.
not for inpatient.
All right. So state. That was Mr. Dunn. My understanding is the state wanted to continue her.
Yes, they were asking to continue and extend for 2 years as well as DDRF. And we were asking, we weren't opposed to the continuation or to the extension, Your Honor. We were just asking for outpatient treatment, given the circumstances with the difficulty getting into DDRF and for SATF.
All right. And so in reading violation of condition number 15, I think the name in that violation is incorrect.
It is, Your Honor. And I discussed that with the CLO, at least the main one. She was aware of that issue.
This is a huge moment right here. When a defendant pleads true to a probation violation, they're basically admitting the violation happened. That gives the judge full authority to revoke probation entirely. So the stakes just jumped from warning to possible jail time instantly.
Both violations that are alleged are still for Ms. Brown. I think there was just a typo in the name.
All right, so you have no objection to the oral amendment to the correct name in the violation of condition 15? All right, so Ms. Brown, have you ever been out of custody since you've had this charge?
Well, yeah.
All right, so have you been out of custody while you've been on probation before?
Yes, Your Honor.
All right, so,
I'm sorry.
no problem.
I've just been here since January.
All right, so you were placed on probation and then you were out of custody, is that correct?
Yes.
All right, and my understanding, we had DDRF was not available because of her length of probation.
Correct. She would need at least 1 year remaining for DDRF.
Okay. All right, so who were you living with?
My mom.
And has anyone talked to her mom to see if her mom wants her back in the home?
I have not been in contact with her mother, Your Honor.
All right. Do you have your mother's number?
Yes.
All right, so this is what we're going to do, because I don't want to set her up to fail. If you'll give her number to your counsel, then if you and probation can speak to her to see if she is okay with her going back to her home, then I'll be able to have an idea of what to do with this case.
Okay, can do that, Your Honor.
All right, thank you.
Thank you.
And probation, is drugs an issue in this case? Or I should say illegal substances?
I don't show any recent UAs, Judge.
Okay.
Probably because she had been in custody for these evaluations. The last UAs were failed to submit and a negative back in July of last year.
Okay, so what's going to end up happening, your attorney, you're going to give him your mother's number, and then the attorney in probation can speak with her. And if for some reason that's not an appropriate place for you to live, then we will figure out somewhere else for you to stay.
Thank you, Your Honor.
All right, thank you.
All right.
Probation, on this case, before we go on the record, is there a place for her or something we can do if her mother decides not to let her live with her?
I can see what housing resources we've received from our reentry specialist
Okay,
and print those out for her just so she can have for her release.
all right. And then we're going to go back on the record in 2023 CR 0042, State versus Brittany Brown. So, Miss Brown, have you talked to your mom on the phone? All right. Did you ask her if you could stay with her? And what did she say? All right. Here's the thing. If I go on your word and allow you to live with your mom, probation is going to call. And if your mother says you can't live there, you can't live there. All right. So I'm going to deny the motion, alter and amend conditions to include MIC, because I see where she is eligible for MIC, correct? So we'll place her on the MIC caseload. And do you have a case manager or anything of that nature with Center for Healthcare Services?
I need to get back over there on Fredericksburg to my doctor.
All right, so we're going to do a referral to Center for Healthcare Services. You're going to need to provide a release to probation. And you need to let them know who your case manager is. And you to reside with your mother.
And notice how carefully the judge walks her through the consequences. This isn't just procedure, it's protection. Courts do this to make sure no one can later claim they didn't understand what they were agreeing to question for you. Would you still plead true, knowing jail time is on the table?
And you're to make sure that probation has that address. Do you understand? Probation, is there anything else she needs?
The only other thing, Judge, would be if you want to order some type of outpatient component for her, the dual diagnosis outpatient.
All right, we'll do dual diagnosis outpatient. And my previous conditions will stand. And there's also to be no unsupervised contact with minors. And counsel, once she is stable on all her medications, you can always come back and change that. So for now, if you want to be around minor children, even if they're your own children, your mother or some adult that's approved by probation must be present. And that's just until you get back stabilized on your medications. You understand?
Yes, Your Honor.
Is there anything else you need from the court? All right, we can go off the record. Here's the thing. If there are issues or something's happening at your house, maybe you and your mom are not getting along. Because I tell people all the time that when you live with somebody else, if you're living in their space, their rules apply. No matter how old we are and it's our mom, if they want the television off at 10, TV must be off at 10, whether you're 12 or 30. All right?
Right.
If something happens where you all get in an argument and she say you have to leave, don't just throw your hands up. If she wants you to leave, you come back to court or call your probation officer and we'll figure something out. Don't just fall off the face of the earth and then you're back in blue. You understand?
Yes, Your Honor.
All right. Good luck to you.
Thank you, Judge.
You're welcome.
Have you excused?
Yes. All right. On Cristobal Gomez.
I think today was the deadline for plea, Judge.
Yes.
We've conferred with the state. I've conferred with my client. At this point, we do not have a meeting of the minds.
All right. So Mr. Gomez, your plea deadline date has expired. The court will not consider any plea bargain agreements without good cause. Otherwise, you'll have to plead open to the court. Do you understand?
Well, I was gonna ask you, ma'am, if I can drop it down a little bit. I mean, I'll sign that.
No. Here's the thing.
Yeah.
And I want to tell you some rules because sometimes I know that people don't know the rules and especially the legal rules, right?
Yes, ma'am.
These are the legal rules. I am not a part of your plea negotiations with the state.
Okay.
What ends up happening is the state will tender an offer. Once they tender an offer, your attorney is ethically bound to tender that offer to you.
Mhm.
You have a choice. You can either accept it or reject it. Sometimes you can make what's called a counter offer. And what a counter offer is, if you tell your attorney, I won't accept A, but I will accept B, then your attorney is ethically bound to go to the state and say, my client will not accept A, my client will accept B. You understand?
Yeah.
But I am not a part of your plea negotiations.
But I never had an A or a B.
Well, here's the thing. When I say A or B, I'm going to ask you some questions. I don't want to know what the offer was to you. Did your attorney come to you and tell you this is what the state is offering you? Yes or no?
Yes, ma'am.
All right, that's an A.
Okay.
All right. Did you tell your attorney you did not want to accept what the state was offering?
Yes, ma'am.
Did you tell your attorney what you would accept from the state?
No.
You haven't told him what you would be willing to accept?
Well, I asked him.
No. Yes or no? Because I'm not trying. So you haven't told him that you would be willing to accept a different offer?
No, I have not.
This is where the emotional weight hits. She's been off her medication, separated from her kids, and now begging for another chance. Judges hear stories like this every day, but the question is always the same. Is this accountability or desperation?
All right.
I've conferred with the state judge. There's no wiggle room. So at this point,
All right. So what your attorney is telling the court is that the offer that you want from the state, there is no need for him to go to the state with that because the state is saying they are not going to go below whatever they offered. Do you understand?
Yes, ma'am.
So you understand that?
Yes, ma'am.
Have you internalized it?
Yeah, no, I got you.
All right.
Thank you.
So is there anything you don't understand?
No, I understand everything.
All right. So whatever the state offered you, they're saying they're not going below that. Is that correct?
Yes, Judge.
All right. So then what I need to know from you is whether or not you're entering into an agreement with the state or not.
No,
All right. So you want a jury trial. That's where we are. Well, I mean, if the state is not going to give you what you want, then and you're not going to accept what they're offering, then the next step is a jury trial. Okay.
Okay.
All right. How long do we all expect this trial to last?
2 to 3 days. It's not gonna be a long one.
All right, Ms. Ferguson, I need a jury trial date on Cristobal Gomez. Thank you. And she's gonna give me a date. That will be your jury trial date. Counsel, if there's an issue with this clothing exchange, just let the court know. You're going to be brought over to court for trial in whatever clothing you were arrested in. If you wish to be attired or dressed in something different, you'll need to do a clothing exchange with your attorney. If your attorney is having some sort of issue with the clothing exchange, they'll let the court know and we'll see what we can do to expedite it.
We'll get him close, Judge.
All right, thank you.
Judge, actually, August 6th.
All right, your jury trial date is going to be August 6th.
Thank you, Judge.
All right, thank you. And counsel, have you all already done an acknowledgement of discovery?
I'm not sure. No.
All right, if you all do an acknowledgement of discovery before you leave. All right, thank you. All right, are you going to have witnesses?
Yes, Your Honor.
All right, let's call this back in the afternoon then. Norma, Jaime Torres is going to come back at 2. All right, we'll bring you back at 2 with your witness.
Yes, Your Honor.
All right, this is Jaime Torres. Manuel Sandival, are you all ready to proceed?
All right.
Court is calling 2023 CR 3142, State of Texas versus Manuel Sandival. Can I have parties announced for the record? For the state,
Zach Dunn for the state, Your Honor.
defense,
Matthew French for Mr. Sandoval, I'm ready.
and are you Manuel Sandival?
Oh, yes, ma'am.
Did you review the document entitled?
Here's the critical issue treatment programs telling someone to stop prescribed medication is a legal and medical minefield. The judge makes it clear don't stop meds without a doctor. This one detail could determine whether probation helps her or sets her up to fail.
Motion to revoke community supervision with your attorney. Did you understand it?
Yes, Your Honor.
Are you the same Manuel Sandival who was placed on community supervision in 2023 CR 3142 for the offense of assault family, second offense on August 29, 2023 for a term of 6 years? Is that you?
Yes, Your Honor.
State?
Your Honor, on or about the 9th day of January, 2024, in Bear County, Texas, the defendant, Manuel Sandoval, did then and there fail to attend and complete Bear County CSCD's substance abuse intensive outpatient treatment program in violation of condition number 30.
How do you plead to that? True or not true?
True, Your Honor.
And the state will waive and abandon the other violations, Your Honor.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 30, the court could find it true, grant the motion, sentence you up to 6 years in the prison and up to a $1,500 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 30?
Yes, Your Honor.
All right. Court will find 30 true. Is there a proposed agreement?
There is a proposal, Your Honor, yes.
Yes.
I think state had let it be known to counsel, the drug use was a primary concern. Following the recommendation for amending of conditions to include SATF followed by aftercare. And I know counsel wants to speak on some more things, but that is the proposed recommendation.
All right. So I'm not going to follow that agreement. This is not his first motion to revoke, and I had already previously put those conditions in place, and there has been no follow through.
Well, he's not been into an inpatient treatment program, Judge. He's agreed to do that today. Judge, just a little bit of background. He was having difficulty. It's referenced in the reports to the court. He was having trouble with finances, keeping jobs. He was doing odd jobs. He's also in this time period, Judge, his father was diagnosed with prostate cancer and has been given only about 6 more months to live, which is the time is ticking on that as well. So he has some other issues that he was dealing with. He understands the situation. He's asking the court to follow that agreement. I understand the court's concerns about it, but drugs seem to be the issue for him, and he's willing to go to that inpatient treatment, Judge. He still has quite a bit of time left on probation, so the court could continue to monitor him after that drug treatment.
All right. This is what the court is going to do. The court is going to grant the motion. There's an affirmative finding of family violence. The court will sentence you to 3 years in the prison, give you credit for any time served. There's to be no contact with Sands, S-A-E-N-Z, Andrade. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
So did Your Honor.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegation in the motion, not the fact that you are on community supervision. The court will request therapeutic community for you. Whether or not you're placed in that is not in my jurisdiction to order, but I know they will definitely not consider that for you if you do not request it. It does not increase the time that you're in custody. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Judge.
This is actually a break for the defendant. The judge denies harsher modifications and opts for structured outpatient care instead. That tells us the court still sees rehabilitation potential, but it comes with strict conditions. One misstep, and this leniency disappears. And this is the contrast that matters. In the very next case, the judge does not show the same flexibility. Prior violations plus no follow through equals prison time, same courtroom, same judge, very different outcomes. So what do you think really decides who gets another chance?